Hey there, this is Jennifer Collins. Welcome back to the videos where I'm reading to us the Arkansas Real Estate Commission rules and regulations. These can be hard to focus on for me, so what I am doing is making videos for myself that later I can post if somebody wants to read them and learn. Okay, so far we're at Real Estate Commission. We did Regulation 8, Regulation Section 8, and I'm reading from the Quick Reference Guide. This is going to be starting at 10.7, and we're talking about the handling of funds and maintenance records, and we're going to go all the way to 10.9. Okay, ready? All right. Oh, actually, we're going to do... let's see, knowledge of property. Let's do 10.6. Knowledge of property. A licensee shall exert reasonable efforts to ascertain those facts which are material to the value or desirability of every property for which the licensee accepts the agency, so that in offering the property, the licensee will be informed about its condition and thus able to avoid intentional or negligent misrepresentation of the public concerning such property. All right, 10.7. Handling of funds, maintenance of records. Okay, ready? A1. A licensee shall immediately deliver to the principal broker any money or other consideration received in connection with a real estate transaction which belongs to others, such as escrow or trust funds, clients' monies, earnest monies, rent, advance fees, deposits, etc. 2. A broker shall deposit all advance fees to the broker's trust account and shall disburse such funds only in accordance with the terms of written agreement signed by the owner of the funds. If such written agreement is not received within a reasonable time after payment of the advance fee, the fee shall be refunded to the owner. 3. Advance fee means any fee charged for services to be paid in advance of the rendering of such services, including, without limitation, any fee charged for listing, advertising, or offering for sale or lease any real property. Okay? B1. Each principal broker shall maintain complete records of all real estate business handled by that firm. Separate files for each real estate transaction conducted by the firm shall be maintained and shall contain signed copies of any of the following documents which were prepared in connection with the transaction: listing contract, agency contract, offer and acceptance contracts, and closing statements, along with any additional documents as may be necessary to make complete record of each transaction. So the principal broker shall maintain complete records of all of that real estate business handled by that firm. Okay. Each principal broker shall maintain complete records pertaining to the property managed for others. Such records shall include all contracts, financial transactions, receipts, statements, repair estimates, and other documents relating to management of that property. 3. All records required by Regulation 10.7 shall be maintained by the principal broker for 3 years or such time as may be required by law, whichever is greater, and shall be open to inspection by and made available to the investigative staff of the Commission at the firm's office or other location designated by the Commission. All records required by Regulation 10.7 may be maintained in an electronic form, provided that copy of the records can be produced as required by this regulation. When a real estate firm ceases to do business and to maintain an office, the last principal broker remaining with the firm shall be responsible for all the records of the firm, including the firm's real estate trust account and transaction records at the time of the real estate firm's office is closed. The principal broker shall immediately notify the Commission of the address and the phone number of the place where those records are being maintained. If for any reason the broker delivers custody or responsibility for those records to another person or firm, he or she shall immediately notify the Commission of such transfer and furnish the name, address, and phone number of such person or firm. They're serious about their records. Keep your dang records. Okay. 10.8. Trust funds and trust accounts. Trust funds means and includes money or other things of value not belonging to the principal broker, but which are received by the principal broker or any of the principal broker's licensees in connection with a real estate transaction or real estate activity, including without limitation clients' money, earnest monies, rent, advance fees, deposits, etc. For purposes of the Arkansas Real Estate License Law and Commission regulations, any funds deposited in a broker's trust account are presumed to be trust funds. Okay. B. Except as provided in Regulation 10.8, a principal broker shall not commingle trust funds with personal funds or other non-trust funds, and shall not deposit or maintain trust funds in a personal account or any kind of business account except the specifically designated trust account. Do not be touching their money. It has to be accounted for. Got it? A principal broker who received trust funds shall either maintain a separate trust account or shall have an escrow agent for all such trust funds. The principal broker of the firm shall be solely responsible and accountable for any funds delivered to an escrow agent selected by the principal broker, but shall not be responsible for funds delivered to an escrow agent selected by the parties. Except as authorized by Regulations 10.8 and 12.2, the trust account shall be non-interest bearing. The name on the account shall include either trust or escrow and must be located in an institution insured by either the FDIC or some other insuring agent of the federal government. A principal broker may maintain the broker's own funds in a designated trust account only when they are clearly identified as the broker's deposit and only for the following purposes. Okay. 1. If the bank in which the account is maintained designates a specific minimum balance that must be maintained in order to keep the account open, the broker may maintain that amount in the account designated as the broker's funds. 2. Okay, this is saying a principal broker may maintain the broker's own funds in a designated trust account only when they are clearly identified as the broker's deposit. Okay, so it must be the broker's own funds only if If the bank in which the account is maintained requires a service charge to be paid for the account, the broker may maintain a reasonable amount to cover that service charge in the account in the broker's name, provided, however, that such amount shall not exceed the total of 6 months' service charges. With regard to each separate trust account, the principal broker shall submit to the commission in writing the following. 1. Name and number of the account. 2. Name and address of the bank. 3. Date the account was opened. The principal broker shall keep the commission informed at all times of the foregoing details of each separate trust account. In addition to the requirements of Regulation 10.8, the principal broker shall submit the same information in writing immediately upon any of the following events or occurrences. 1. Commission approval of real estate firm name. 2. Change of real estate firm name. 3. Designation of new principal broker. 4. The account is changed in any respect or closed. Okay, no later than 3 days following the execution of a real estate contract by both seller and the buyer, all trust funds delivered to the principal broker shall be either deposited in the trust account, delivered to an escrow agent, or deposited pursuant to a written agreement by the seller and the buyer. All other funds delivered to the broker pending performance of any act shall be no later than 3 days, either deposited into the trust account, delivered to an escrow agent, or deposited pursuant to a written agreement by the seller and the buyer. Should the third day be a Saturday, Sunday, or legal holiday, then the third day is extended to the next day, which is not a Saturday, Sunday, or legal holiday. The broker shall maintain an accounting of all funds delivered to the broker and shall keep a signed receipt for any funds the broker delivers to an escrow agent. The broker remains responsible for the funds if the broker selected the escrow agent, but not if the parties selected the escrow agent. A broker shall at all times keep detailed records of all funds coming into the broker's possession and all disbursements made by the broker. 2. All trust account bank statements shall be reconciled in writing at least monthly and balanced to the total amount of trust funds deposited in the account which have not been dispersed. Copies of such reconciliation shall be kept by the broker for at least 3 years for such time as may be required by law, whichever is greater. 3. All trust fund records, including bank reconciliations, shall be open to inspection by and made available to the investigative staff of the Commission at the firm's office or other location designated by the Commission. All security deposits made under a rental or lease agreement shall be deposited in the principal broker's trust account, including those deposits made on property owned by any licensee licensed under the principal broker, unless the licensee who owns the property has a written agreement with the tenant providing that the licensee may keep the security deposit in the licensee's separate account. A copy of any such agreement shall be furnished to the principal broker by the licensee, provided, however, that the principal broker shall not be responsible for the failures of those licensed under such principal broker to comply with Regulation 10.8, as long as the principal broker is in compliance with Regulation 10.4. Nothing in this Regulation 10.8 shall be deemed to prohibit a broker from maintaining certain funds or deposits in particular transactions in an interest-bearing account when required to do so by law or valid regulation of any government agency, nor shall it prohibit a broker from maintaining an interest-bearing account while participating in the interest on Section on Real Estate Brokers Trust Account Program authorized by Section 24 of Act 690 of 1993 and Regulations 12.2 and 12.3. 10.9. Disbursement of trust funds. A principal broker shall not disburse trust funds from the broker's designated trust account contrary to the terms of the contract for the sale or rental of real estate or other contract pursuant to which the funds were received, and a principal broker shall not fail to disburse trust funds according to the terms of the contract. Except as otherwise authorized by Regulation 10.8, the balance of a principal broker's trust account shall at all times equal the total of the trust funds received for which the broker is accountable. Don't be spending other people's money. A principal broker who disburses trust funds from a designated trust account under the following circumstances shall be deemed by the Commission to have fulfilled properly the broker's duty to account for and remit money which the broker is required to maintain and deposit in a designated trust account. 1. Upon the rejection of an offer to buy, sell, lease, rent, exchange, or option real estate. 2. Upon the withdrawal of an offer not yet accepted to buy, sell, rent, lease, exchange, or option real estate. 3. At the closing of the transaction. 4. Upon securing a written agreement which is signed by all parties having an interest in the trust funds and is separate from the contract which directs the broker to hold the funds. 5. Upon the filing of an interpleader action in a court of competent jurisdiction. 6. Upon the order of a court of competent jurisdiction. Or 7. Upon a reasonable interpretation of the contract which directed the broker to deposit the funds. D. When a broker makes a disbursement to which all parties to the contract have not expressly agreed in writing, the broker must immediately notify all parties in writing of the disbursement. Okay, that's it for now.